need to mention this is lastly matter, my lord. I am mentioning upon notice, my lord. My lord asked me to mention so that it can be appear as a, so that it can appear as a to be mentioned. My lord will prepone the date.
Monday.
I'm mentioning in company matter, the Gauripur Company Limited. There is an application CA76. There is application filed by
Come on Monday. When the company matters will be taken up, mention at that time.
Okay.
Origin side commercial division, item number 1.
I appear for the plaintiff. Pursuant to your lordship's direction, my lord, the suit was transferred to the commercial side. And I was directed, my lord, to serve fresh writ of summons. My lord, I have lodged.
Who is for the defendant?
They were not appearing, my lord, when the suit was undefended, my lord, were in the regular list. My lord, I have on 24th December lodged the writ of summons. But now, my lord, the department needs to.
The landed registrar original side shall furnish a report on date of service of summons, comma, after transfer of the suit to commercial division, date of appearance of the defendant, as well as date of filing of the written statement, if any, on the returnable date.
There is no written statement.
No, that's why the report is asking for.
Yes.
The suit will appear in the list on 7th March.
Item number 2. Commercial
I appear,
division.
my lord, for the defendant number 2, my lord.
Who is the plaintiff?
My lord, none is appearing. My lord, on the last occasion, your lordship had called for a report, my lord, from the, my lord, the landed registrar. There are,
Defendant number 2.
my lord, I appear for the defendant number 2.
You have not filed written statement.
Lordship, kindly give me 2 minutes. My lord, what happened is, initially, my lord, in the suit, I was not a party. The suit was filed, my lord, by the plaintiff against, my lord, ICICI Bank. My lord, thereafter, my lord, I took out an application, my lord, for addition of party. Now, my lord, in that application, in an appeal, my lord, Justice Shonji Banerjee, my lord, allowed, my lord, my participation in the suit. Now, my lord, that is an order, my lord, which was passed on September 24, 2018. Lordship will kindly take a look at this order into the event. My lord, since then, they have not, my lord, taken any steps, my lord, to, my lord, serve the writ of summons on me. My lord, the writ of summons, my lord, as per the original side rules, has to be taken out. Until and unless, my lord, that is taken out, my lord, neither,
Who is
my
for
lord,
the plaintiff?
My lord, I am appeal for the
My-
plaintiff.
my
Have
lord,
you served?
My lord, my advocate on record is not here, my lord, but my instructions are, my lord, that we cannot serve because they have not entered appearance or filed wakalatnama. My lord's last order, my lord, has called for a report from the registry.
Yes, I have got that.
And
may I,
Verification.
my lord, place, my lord, the original side rules once. My lord, I don't know, my lord, what my learned friend is submitting. My lord, let him, my lord, show that in the original side rules, entering appearance precedes, my lord, service. Let him show, my lord. I will, my lord, place, my lord, one second. Lordship will kindly take, my lord, the
Serve
original.
the summons then.
my lord,
Lordship will kindly take the original side rules once for my satisfaction, my lord.
Which one you are referring to?
My lord, Lordship will kindly take chapter 8, my lord, rule 3. Lordship will kindly take summons when returnable. My lord, my client, my lord, stays in Bangalore. So, my lord, what is applicable on me, my lord, is clause 3 of rule 3, my lord. Elsewhere in Union of India. Lordship has got it. My lord, why the defendant resides or any of the defendants reside elsewhere in the Union of India 11 weeks from the date of the writ. So, my lord, it has to be, my lord, 11 weeks from, my lord, the order passed. That is in 2018. They have not taken that. Only then, my lord, after, my lord, rule 3, my lord, comes rule 4, my lord, wherein, my lord, the writ of
When the
summons.
summons are not lodged, do you know what is the remedy for you?
No, my lord, that is the thing, my lord, that they want. They don't want my participation in the suit, my lord. That is why, my lord, I was not initially made
Very
a
good.
party in the suit.
Very good. You are now added party.
I am an added party. So, to cut the matter short, my lord, that's what I had submitted, my lord, on the last occasion also, my lord. Let them hand over a copy of the plaint to me here and now. Lordship will kindly give me a leave, my lord, to enter appearance
Yes.
after my return statement. That will, my lord, solve the issue.
My lord,
I don't, in fact, my lord,
Learned
Lordship
counsel
will
for
find-
the plaintiff.
my lord, may I also submit, my lord, may I file the additional affidavit of documents, my lord, my previous.
that will come later, my lord. Later,
First
when
you serve the
written
notice.
statement.
Report of the learned fresh report of the learned registrar original site dated 20th January 2025 be kept in record. The learned counsel for the plaintiff candidly admitted that copy of the plaint has not been served upon the defendant number 2 who has entered into appearance.
No, I've not entered appearance. Well, I haven't added as a party.
I have
Defendant.
not
who-
entered appearance, my lord. That is the
Let me finish.
Sorry.
Who has made appearance after addition as a party. Order was passed on 24/9/2018, pursuant to which he was added. The plaintiff shall serve a copy of the plaint as amended on the defendant number. Who is defendant number 1? Have you filed WS?
We have not.
On the added defendant number 2 within 7 days from today. Let the matter appear in the let the suit appear in the list for further order. On 5th February.
Lordship, may I, my lord, suggest this, my lord? Instead of, my lord, serving it on, my lord, the defendant number 2, because he resides in Bangalore, she resides in Bangalore. What they can do is there are a lot of litigations, my lord, between these parties. Both the advocate records, my lord, know each other. It's, my lord, so they can, my lord, what they can do.
I
they
have
can,
passed
my lord,
order if they can serve a
what they did, my lord, I'm telling you why I'm saying this. My lord, on the previously, my lord, what they did, they had sent a copy, my lord, to an address where, my lord, the defendant number 2 does not reside. That is the problem. They will once again, my lord, serve it there, and my lord will delay the whole
short
process.
service is permitted
Let them, my lord, serve it on the advocate. My advocate record will write a letter, my lord, to them.
through the learned counsel of the for the.
And, my lord, in that event, my lord, may I leave may be granted, my lord, to file the wakalatnama in that event, my lord.
You have
in the
not
event-
filed wakalatnama.
My lord, until and unless they serve.
Liberty is given to file wakalatnama in the meantime to the defendant number 2.
And my
may
lord,
I serve it on the advocate on record of the defendant.
Yes.
Yes.
The permission is given.
That's what I'm asking long back, my lord.
Lord, may I add one more? Discovery inspection of the current office has been completed.
Have you filed WS?
Yes, we have filed.
You said just now. You said no.
Heard that the
Find it out. Let this part be over. Then I will look into that.
My lord, on the
has been filed.
on the next occasion, my lord, may I, my lord, seek leave,
For
my lord, to
further
file-
order, come on the next date.
My lord, I will come back.
Item number 3.
Item number 3, my lord, I am for the plaintiff, my lord. On the last occasion, lordship called for the copy of the decree from the department, my lord. Kindly see the last order, my lord, 2nd of December 2024, my lord. Last line, my lord.
This is undefended suit.
Yes, my lord. Undefended suit. Second page, my lord. We have communicated the order to the learned registrar. Decree has to be called for,
Why the decree is to be called for?
my lord. That was not in the record of your lordship, my lord. Probably that for that reason, lordship called for
The suit
the
is
decree.
decreed.
Judgment on admission was passed, my lord, of 47 lakhs and odd out of 61 lakh.
Then
61
why the
and
suit
odd.
is pending?
My lord, kindly come to lordship last order, my lord.
Why
2nd
the suit
December.
is pending? Why the suit is pending then?
My lord, partially decreed, not fully.
Or for interest part?
Interest not, admission part was decreed, and which they have not admitted.
Where is the decree?
That was pending, my lord. For that reason, this suit is pending. Lordship has recorded on the last order, my lord.
Order sheet দাও। Copy of the decree.
Yes, my lord, lordship recorded.
Where is the judgment?
Judgment dated, my lord, 23rd November 2017, my lord.
ডিক্রিটা দিয়েছে? সাইন হয়েছে, ডিক্রিটা কোথায়? কপি অফ দি ডিক্রি বললাম। এটা সেটেল হোক, ডিক্রিটা কোথায়? আমি তো বললাম কপি অফ দি ডিক্রি। Come some other day.
Grateful, lordship.
Adjourn to 27th February.
Yes, ma'am.
Item number 4. At item 4, my lord, I appear on behalf of the defendant petitioner. Lordship might
What is
recall-
GA Com 4?
That's, my lord, my application for dismissal of the suit. My lord, Lordship had heard this matter.
Exchange of affidavit is complete.
Yes, completed. We had argued the matter, my lord. Lordship might recall, my lord. Their claim, my lord, is twofold. First is 3 paragraphs that Lordship sees. Lordship has taken note of it on the last day when I was arguing. Their claim is twofold. First for non-supply and second is for refund of earnest money. We say both their claims are ex specie barred by the laws of limitation. And in that regard, my lord, while placing, my lord, the 3 judgments, my lord, I first showed your lordship the 3 paragraphs of the plaint, my lord. Lordship might recall paragraph 4, 3, 4 and 5.
Is demurrer application on the ground suit is barred by limitation?
Absolutely.
Beyond 3 years. That is the only point.
Now, only point, but relating to 2 aspects. Claim twofold. First, non-supply. I say admittedly, my lord, regarding non-supply, my lord, they have filed a suit after the period of 3 years. And to establish that, my lord, I will not refer to paragraph 3 of the plaint, which says that the bill was lastly submitted on 14th of March. So supply, my lord, had to be made or had been made, certainly, my lord.
Paragraph?
Paragraph 3 of the plaint. Just to, my lord, recapitulate, my lord. Paragraph 3, lordship had taken note of it. So, my lord, supply
Submitted bill on
14th March.
14/3/2010.
So supply must have been made before that. Now, my lord, kindly sees the date, my lord, when the suit has been filed, admittedly after the period of 3 years. So first claim goes on that. And relating to another thing which they have claimed, that is, my lord, for refund of the earnest money. We deducted, my lord, and earnest money had not been refunded. That's their second claim. Lordship, it comes to, my lord, paragraph, my lord, 8. Their entire claim has been narrated. Paragraph 8, page 12 of the plaint. Lordship has got it. Lord. Claim number 1, Lordship would
Payment for dolomite supply.
Yes, that is for supply and admittedly had been filed after 3 years.
Refund of forfeited
Yes.
money.
2 and 3, these 2 and 3 refund, both are refund, and they have quantified at 23 lakhs and odd. I said that is also
What is the status of the suit?
not them.
Examination in chief has started.
Mhm.
Examination in chief has started. And thereafter. my lord,
Mr. Bose's witness was in the box.
and then
Few
that's
questions
the-
were put. Then, my lord, we filed it. And the second claim, I also say it's barred because paragraph 4 and 5, if Lordship my lord reads together, Lordship would find they have referred to a particular letter. And Lordship my lord asked me this question: if the letter is taken into
Yeah,
consideration,
so your point is prima facie suit is barred by limitation
Yes.
from the plain reading of the plain.
both claims, both. First, my lord, the principal, and the second one, my lord, refund. And 3 paragraphs, and I cited 3 judgments, my lord, on the last day. Now, my lord, they have to give reply. One, my lord, Lordship might recall, I had handed over the copies. First one, which I cited before your Lordship, my lord, is reported in 2007, volume 5, Supreme Court cases 614, paragraph 25, which clearly says that if the claim is ex facie barred by limitation, then the suit has to be dismissed.
First you refer to
First one, 3 judgments I cited. And first one, 2007, volume 5, Supreme Court cases 614.
আরেকটা থাকবে।
3টে দিয়েছিলাম দেখবেন। Other one, 2014, volume 14, Supreme.
That 14 is not available here.
14 is not there. Tinte dekhiyechilam.
Which para you're referring to? Possibly you
The Lordship is looking
para
at
25.
Yes, 2007, paragraph 25. It's absolutely on the point. Subject to, of course, satisfaction of the facts. Paragraph 25.
2014 বলে cite করিস নি,
না, আমি
আমাদের
করেছিলাম site.
what's the reference?
2014 তে করেছিলাম।
And so far as 2005 is concerned, you refer to paragraph.
Sorry, I probably made a wrong submission. I cited 2007, volume 5. Then 2000.
Yes, in 2007, volume 5, you refer to para 25.
I cited.
So far as 2005 is concerned, you focused on paragraph 3.
Yes. Yes. I didn't cite 2014. So Lordship for the time being can ignore. I'm sorry, my lord. Lordship was absolutely correct.
These two judgments.
And the other one, my lord, delivered by your lordship, my lord, unreported one. I referred to that also. And I handed over a copy.
2014 is also there.
2014 is there, but I don't think I had formally cited. So for the time being, lordship can ignore it.
Let it be kept in record. Let
Very
me
well,
see.
very well. Then 2014 also supports my case, my lord.
That is in para 5.
2014, right now my junior has handed over 2 paragraphs. 2014.
Mainly para 5.
No, yes, and para 7 and 12 also.
Para 7 and 12.
All on limitation. Paragraphs 7, lordship sees, my lord.
Page 2014.
2014.
7 and 12 focuses on factual aspect. 5 is on legal aspect.
Yes, but 7 has to be read because it says about 14 years.
The factual background.
Yes, and the 12, my lord, lordship would find
7 and 12 discusses the factual aspect,
Absolutely.
factual backgrounds.
the page is, my lord, 254.
Yes, I've got it.
And the last one, lordship's judgment, my lord, on this, my lord, I, my lord, placed.
Which one?
Kunta bola? No, no, okay, I'd handed over on the last day, my lord. On an identical point, my lord has held, my lord, if the claim is ex facie barred by limitation, there is no need to go to trial. It has to be dismissed. And these are my submissions. Now, reference I'd handed over on the last day, my lord. This one. Judgment delivered by your lordship on 19th of July 2024. The case number is Mrs. Maiti and Company versus State of West Bengal.
Yes, 2 suits are there.
Yes.
Both the suits are dismissed.
Absolutely. I can hand over, my lord. So I rely on these judgments, my lord, and 2 articles I have referred to, my lord. Lordship might take a note of it, my lord. Limitation Act. Last few paragraphs, my lord, court's finding is recorded, my lord.
I've taken note of that. You have made some underlines, so I won't accept it.
Oh, very well, my lord. I would hand over a different copy.
I will get it.
I will hand over a fresh
I'll
copy, my
remember.
lord. I'm sorry, my lord. Maybe
No
it's
issue.
been marked by my. And my lord, 2
Yes, let me
articles-
hear, Mr. Bush.
Yes, and 2 articles, my lord, I had referred to, my lord, Article 14 and Article 100. Article 14 says, my lord, suit which is for the price of goods sold and delivered when no fixed period of credit is agreed upon, it has to be filed within the period of 3 years from the date of delivery of goods. And the other one is, my lord, Article 100, because their second claim for refund of honest money is based on a report which has not been challenged. And it said it has to be done within a period of, my lord, 1 year from the date, my lord, final decision has been taken. So decision taken for non-refund of the honest money, my lord, taken, my lord, some time back. And admittedly, they have filed it challenging that, claiming the refund after a period of 1 year.
All
These are
right.
my submissions.
My lord, before I address your lordship on the merits.
এই
of
ওটা
the
দেখি,
law-
Fresh copy.
এইগুলো নিয়ে নাও।
My lord, before I address your lordship on the merits and the law, there are just 2 or 3 things I would like to draw your lordship's kind attention to. The suit was filed in the year 2013. Writ of summons had been served. They did not file any written statement. In spite of service and notice, they did not appear to contest the suit. The suit was decreed ex parte after taking evidence. When they came to know about the decree at the time of execution, they moved an application for recalling the decree. The application for recalling the decree was allowed, and they were directed to deposit the entire amount in court, which they did. Thereafter, my lord, they made an application for extension of time to file written statement. Naturally, since the decree had been recalled, they were allowed to do it. Thereafter, my lord, the suit was transferred to the commercial causes division. Throughout, the point of limitation was never taken. So many things appeared, so
WS
many
देखिए।
points, so many points, so many days the matter was taken up, it was not taken. It is interesting to note that after the suit was transferred to the commercial division, my lord, till then, my lord, no point of limitation taken. I filed my affidavit in support of my examination in chief.
Just a minute.
In the written statement also, it's not there. And your lordship knows this is a mixed question of law and fact. I shall demonstrate to your lordship, my lord, that at this stage to suddenly take this stand after the pleadings and after the documents on record is perhaps not permissible. More so since the suit has already started, my witness is already in the box, part of the evidence in chief has already been concluded, and that is because...
I have to go through the written statement carefully.
Then is it my lord's pleasure that I address your lordship on the next day?
Better.
Entirely up to your lordship.
I will let me go through the written statement.
Very well.
Well, only one thing, my lord, in one paragraph, I have read it. Categorically, I have said, subject to correction of what falls from your lordship after looking into the entire written statement. It's barred by law. So that is good enough, my lord, to argue or to find out.
All right.
And the judgment, my lord.
First thing is whether it is pleaded in the written statement. So the second thing is whether at all it is necessary to plead in the written statement. Because limitation
Point of law.
I got
it's
your
the
point.
jurisdiction.
I got your point, my lord. I got
And
your
secondly, then the third most important thing is, if limitation is admittedly a mixed question of law and fact,
Then not
on the
at this
basis-
stage.
Not at this stage, because the plaint has to be read, my lord, as it stands. That is the usual reading of plaints, and that is what the Supreme Court has also said. The plaint has to be read as a whole, and the plaint has to be read.
Only plaint is to be read as a
Only plaint is to be read as a
Absolutely,
whole.
government.
I
nothing
should
more,
show-
nothing less.
I should show your lordship from the plaint as also the annexures to the plaint that both the points sought to be taken by my learned friend have no legs to stand on till such time my lord actually goes into the evidence, which I'm going to lead, which is very apparent from the records.
Come on the next date then.
I entirely leave it up.
My
to
lord,
my lord.
a copy of the judgment. This one is not marked. Lordship can take
Keep it with you. Next day I will take it.
Very well, very well.
My lord will give an early date, my lord, so that it is.
Subject to correction by your lordship and convenience of the court any day in the
I
first,
have a inconvenience today. Problem is that two of my staffs are not.
any day in the first
absent.
week of February,
So I
if it
cannot.
is convenient, or some other day.
7th February is okay.
Absolutely, it's okay with
Sir,
me.
7th February is okay.
It is entirely up to my lord.
7th February. Hard in part adjourned to 7th February.
My lord, instead of 7th, it's my learned Julia's father is going to have a surgery. 9th, any day, my lord. 10th.
12th February.
Very well.
Today, my lord, we have treated this almost a holiday, my lord. Seeing, my lord, the car, the cars, my lord, which have been parked, around the High
Yes,
Court,
lot
and the
of
number
cars.
of lawyers who are present.
Very few number of lawyers
Yes,
are there.
it's a
Although I
half
am not able to see this in my court.
No, it's half, no. Because lordship is extremely popular and everybody wants to do matter before you, my lord. That's the
Not
reason.
that.
Matters are heard. Grateful, my lord.
Regular list, item number 1.
সাত সকালে একেবারে
Regular list, item number 1.
I am appearing for the defendant numbers 15 to 20 in this matter. My lord, this is my application, GA number 3. My lord, I believe the matter is.
what is J number 3?
It is an application for rejection of plaint on the last
Exchange
occasion.
of affidavit is complete.
No, my lord. My lord, there was a direction for exchange of affidavit. We have not received it. The returnable date was 21st of February. If my lord kindly takes up my lord's last order passed on 17th
Yes,
January.
this is not fulfilled. Complied with.
Yes.
Affidavit, exchange of affidavit is yet to be complete. Full stop. Affidavit in opposition has not come before this court as of now. Full stop. Affidavit in opposition shall be filed within 2 weeks. And affidavit in reply, if any, within 2 weeks thereafter. Let the matter appear in the list. Let the application appear in the list for hearing on 10th March.
Much obliged, my lord.
Item number 2, 3, and 6.
For the petition
But I am
laid by Amitabh Mukherjee.
respondent number 3 to 5.
What is one?
My lord,
GA1?
what happened? My lord, may I be permitted to indicate? My lord, all these GAs, my lord, GA number 3. My lord, GA number
No, it's appear GA number
My lord, GA number 3 was my section 8 application. I'm for
2,
respondent.
3, and 6. Just a minute.
My lord, GA number 3, my lord, is a section 8 application. My lord, what happened was, this is my section 8 application by the respondent numbers 3 to 5 of my lord, my lord, the application. My lord, we wanted to send this matter, my lord, before the arbitrator. My lord, this application opposition was filed, readings were completed, arguments were done, notes on argument was also filed. Now, my lord, what happened was, your lordship posted this matter for seeking certain clarifications. Now, the only clarification that my lord
Yeah,
wanted-
escrow agreement.
No, my lord. The only clarification that your
This
lordship
is that escrow agreement.
Yes,
escrow
yes,
agreement
yes.
matter. Escrow agreement matter. Only clarification that my lord wanted was whether the affidavit in opposition was at all filed or not.
Yes, that was the issue.
So the only
sir.
thing that the matter is kept today is for a report from the department as to whether they filed a report.
Have you filed, Leo?
They have filed. They served on me, which is why we filed the report.
They have
with
only
your
served upon you. They
Very
have
good.
not filed this.
Lordship, last occasion, your lordship has directed to department to find out it is
Do
available.
one thing, file another AO.
My lord, let it be reconstructed.
Why reconstructed? If it is not filed, why it will be reconstructed?
My
Why
lord,
are you blaming the
my
department?
lord, my affidavit in
देखिए, और
reply
जरा
should
देखिए।
be there in court. Let them also use the same affidavit
Report
in
আছে তো?
opposition.
Last order, your lordship.
And it was for my lord department's report. Lord, is the report there before my lord?
Let me see whether it was filed in before the department or not at all. Order sheet টা কি আছে দেখো না। Department shall furnish a report, এটা কোথায়? সেটা তো আমি অর্ডার করে দিচ্ছি। Learned Registrar Original Site shall furnish a report in terms of order dated 14 January 2025. Copy of this order as well as the order dated 14 January 2025 may be sent to the Learned Registrar Original Site for compliance. Let the matter appear in the list on 14 February.
My lord, I do not have any objection if they want to put in that affidavit in
You
opposition.
can't understand one thing.
My lord,
First thing is reconstruction may be done when it is filed.
file it when it is.
Now, if I pass order of reconstruction, that
understand.
implies that it was filed before the department and department misplaced
My
it.
my
Why they should bear the blame?
my
Let it be ascertained whether it was at all filed or not.
Yes, sir. Much obliged.
This is 2, 3, and 6.
6. Item number 4 and 5.
There are two applications filed by my client, my lord. One is for extension of time to file written statement.
What is GA26?
Yes, my lord. GA26 is the application for extension of time to file written statement, and 27 is application for expunging of certain properties, saying that one of those particular properties are the individual separate properties of certain parties. So that should not form the subject matter of the partition.
So let us take up 26 first, written statement.
Difficulties,
Your
my lord,
lordship, your lord.
we have solved. Now there is a dispute regarding service.
I have been making several requests to serve a copy on us.
Sir, because my affidavit of service is there. Why should I not serve? There is no question of gaining a heart.
No,
Serve a copy.
Sir,
it has not been served. They say by
All right, you give another copy.
can be done.
hard copy.
Why should I leave? They have served me and by email, but I am also entitled to serve by
I
email.
have served you by email.
I have, but
Copy
I
of the application.
Your lordship, I'm appearing on
I
behalf
don't know
of
what
defendant number 5 to 9. They have served
like
us the
small
copy,
children,
and we
something in
we
court.
shall be filing it by Monday, your lordship. It has just
Yo.
not been affirmed. From 5 to 9, your lordship.
What is
You are for defendant
For
number?
26 and 27.
The learned counsel, Mr. Dashgupta, the learned counsel for the defendant number 4. Sub, what, learned, yes, learned counsel for defendant number 1 to 4, 1, 2, 3, 4. Submitted that copy of GA26 of 24,
27 also.
as well as GA27 of 24, has not yet been received. Full stop. The applicants shall serve a copy of these applications, bracket a hard copy, to the defendant number 1, 2, 3, and 4. Full stop. Next para. The learned counsel for the defendant number
5 to 9. 5, 6,
5
7,
to
8,
9.
9.
6 for extension of time for filing affidavit in opposition against the said two applications,
Yes, your lordship.
namely GA26 of 24 and 27 of 24. Time is extended. Affidavit in opposition shall be filed within 2 weeks. Affidavit in reply, if any, shall be filed within 2 weeks thereafter. The matter will appear in the list on 10th March.
There are
only one thing.
To GA number 18 to 26, 25.
There are other
Like those are deletion application filed by my
that will be taken up later on. Let this service be done first. What is this?
My lord, only one thing, my lord.
Affidavit of what?
Affidavit of service. I am saying that everyone has received it.
Affidavit of service filed by the petitioner be kept in record. Filed by Mr. Shen, the learned senior counsel, be kept in record.
But kindly see, my lord, I have served on the email address of my learned friends at
Very good.
record.
My lord,
Well done.
my lord, one small indulgence, my lord, I am appearing on behalf of the plaintiff, my lord. I have also been served a copy of the GA 26 and 27. My lord, I also seek to.
I have given not as party specific extension and general extension for 2 weeks and 2 weeks.
But everyone has got the copy. Only one person comes and, my lord, tries like a baby.
Today is Friday, a sandwich Friday. So these things are to be passed.
Grateful, my lord.
But hard copy is not mandatory. My lord. If he were, otherwise I would have given him, he would have told me outside.
Then they will come again. Mr. Dashgupta will come again and say, give me a hard copy.
He is a co-defendant. Any event, my lord, he does not have a right.
Maybe.
Item number 7.
Look, I appear for the defendant. Affidavit of documents have been filed, my lord.
These are all complete. Exchange of documents.
Yes, my lord. Discovery
Your lordship.
filed by suggested issues.
Are you filing suggested issues?
Your lordship, I'm filing judge's brief of document. Suggested issues in the meantime, your lordship.
Judge's brief of document is filed by, come on the next then. Is filed by
Plaintiff,
the
your lordship.
learned counsel for the
Plaintiff, your lordship.
plaintiff. Let the same be kept in record. Fix. Giving a short date. Date বলতে পারবে? 6 February. না 6 February তো আমার probate থাকবে। 10 February for framing of issues.
Your lordship, I'm also serving them one copy, kindly recorded.
Copy of the judge's brief of document is also served upon the defendant.
Grateful, your lordship.
Come on that date. 10 February.
Item number 8.
Lord 8, Lord, I appear for the plaintiff.
I appear for the plaintiff, my lord. Only just one indulgence before my learned friend on the other side speaks.
10th February is okay.
No, my lord, it's okay. But my lord, this is the second time the my lord the
Item
defendant.
number 8, Lordship. The advocate on record of the defendant is not in Calcutta. So as such, I seek for a not this week.
I am allowing you.
Okay.
My lord, I'm not opposing, my lord, but my lord, let
Kindly
this,
fix the matter after the
my lord, let this
Wednesday of
direction be peremptory,
10th
my lord.
February.
10th February.
My lord, I'm
No,
not
my lord.
opposing, my lord. Let this be, my lord, let this direction be peremptory, my lord. We are issuing notices.
Let
They
me
are not.
let me understand one thing. Exchange of documents, charges brief, all these things are done.
Yes, my lord. My lord, exchange of documents are all these things are done, my lord. Only, my lord, they have to come and take inspection of our documents. We have written them letters. They are not coming.
ওখানে লিখুন, the inspection of documents are yet to be complete, is yet to be complete. Let the same be complete on or before the returnable date.
My lord, peremptory direction, my lord. Kindly.
Let the suit be given. Let the suit appear in the list on 10th February.
Your
No
lordship,
further,
kindly,
time
my
shall,
lord.
no further time shall be allowed.
Extremely grateful, my lord. Extremely grateful.
Item number 9.
Item number 9.
For the plaintiff.
I appear for the defendants. my
Let
lord.
the undefended, let there be,
Witness action.
witness action, my lord. I have to file the judges before documents in this.
Have you filed it?
And it has not been filed. We have
Accommodation is sought for by the learned counsel for the plaintiff to file judge's brief of document.
the discovery inspection is not required. Actually.
It is undefended suit.
And, on 9th of September, it has been
Then why discovery is an inspection?
Lord, we shall take some applications out to. So Mitro is leading me in this matter.
Undefended suit.
To be honest, man, I'm at a loss. Undefended suit, appearing for a defendant.
No, one thing I'd like to clarify here.
Yes.
Since this is undefended suit, there cannot be discovery, inspection, and all these
No,
things.
can't be.
So, judge's brief of document he is to file. I am accommodating him.
My
If you
lord.
want to file any application,
That I will have to.
yes.
Yes. Lordship will not record there.
No,
that's
accommodation is sought for by the learned counsel for the plaintiff to file judge's brief of document. Accommodation is allowed. Let the matter appear in the list on 12th March.
Obliged. Will take steps.
Good enough for this time. 10 matters, 14 matters. One is left only.
I missed one matter. Commercial item 2. There. Hey. Commercial item. There. Those are
Some other
part and parcel. Obliged.
আস্তে আস্তে করে আমাকে দিন
আমি এই চেকলিস্ট
আচ্ছা ইয়ে দেখুন চন্দ্রদা
কারেন্টে বটে হ্যাঁ কারেন্টে যাবো না
হ্যাঁ যাচ্ছি কোথায় কারেন্ট ঠিক আছে
Mute.
Hello?
हाँ.
Yes, sir.
Today I shall be going to that I have concluded really that I have to hand up to your lordship the synopsis of our argument, notes of submission, and the list of judgments they have given to my learned friend, which are going to cite. But last time, what happened? This is the form we have prepared. Can you see, Milord? It contains index, contains the keywords. Does it?
Notes of argument.
No, so, I mean, well, sorry, Milord. I've given notes of argument. This is the
This is notes of argument.
yes, this is the index of the judgments. If index, if might also pleases, if I may read out the index only, then learned friend will also be knowing why I am citing his judgments. এটা কোথায় ভুল ভাল হয়ে গেছে এটা নয় কোথায় কিওয়ার্ড গুলো আছে যেটা ভুল ভাল লিখছো তোমরা এইটা হ্যাঁ এইটা
Sorry.
এটা
ওটা আমার দাও।
ওটার বই হ্যাঁ এটা রাষ্ট্রপতি হচ্ছে
Yes.
But this is if I may only read out the Dubai learned friend, this last item, interlocutory judgments cannot be looked into at the hearing of the suit. They have given a division bench judgment and Supreme Court judgment in support of that.
Six.
In this case, my lord,
Additionally.
Because those are tentative findings.
tentative finding. That is, no evidence is taken in interview stage. All documents are not there also. So what the suit to decide upon hearing oral evidence and documentary evidence, which interlocutory court did not have, interlocutory judge did not have that opportunity. So that judgment are very clearly stated that the interlocutory judgments are not to be looked into or cited at the final hearing of suit because of evidence. They have in fact exhibited Exhibit M, which is a collective exhibit of all interlocutory orders passed in the suit. That was also allowed to be exhibited, I find, from the records without any objection. But not now, I shall humbly submit, even then, documents which are barred from consideration of the High Court is inadmissible in evidence, and my lord will be pleased not to look into that. That's why given these two judgments. These two judgments were given that court cannot look into that. And my lord, other things are, lordship kindly see, if I may just index, lordship got the index. Learned friend also note, I have given 7 Indian appeals. What is the keywords? Long user of more than 20 years in that case, presume grant of or an agreement of user without any aid of limitation act. Now section 25. At 22 Madras, page 5, same thing, long user of right of way to the defendant's house, which was not part of tenancy of the plaintiff. For clearing the plaintiff's privy give rise to presumption of grant of right of way to the plaintiff tenant. Long user of the right to pass through the defendant's house by tenant for 30 to 40 years in that case, without obstruction for screening plaintiff privy established a right and injunction was granted, restraining the defendant from obstructing the plaintiff. Defendant raised the objection after 30-40 years in October 1917. Suit was filed in 1918 March, which did not defeat the right of the tenant, which had already matured after 30-40 years. Then my next year, 1920 Calcutta, user of right, which does not form part of the tenancy agreement, was uninterrupted for a period of 12 years, established a loss grant of right of way. What they call me a loss grant is implied grant. Loss grant is judicial. Then 1933 Calcutta, the long use of pathway by the tenant for 40 to 50 years without interruption leads to grant and or acquisition of right to use the pathway by the tenant. Another Calcutta good judgment. Another Madras judgment. This is conclusion page 956, right hand column. Landlord tenant case, use of water from landlord's tank for more than 20 years by the tenant, although there is no provision in the tenancy agreement regarding the same, establishes the right to such use. Court held, so after considering number of judgments of Calcutta, this judgment refers to all several judgments of Calcutta, Lahore, Madras High Court. This is a decision taken. Then easement of necessity, when implied. It is judgment of Lord Denning, I give a reference. It was held by Lord Denning that easement of necessity in favor of tenant is implied unless expressly excluded by tenancy agreement, which is not so in Exhibit A in our case. Exhibit A means don't expressly exclude the right of use of the compound.
But use it for specific way, specific manner.
But we use it compound for specific purposes, no doubt all tenants use it. But the Exhibit A does not contain any provision that tenants, or at least my client, would not have a right to use the compound for egress and egress from the backside of the showroom and vehicular traffic. That is no express prohibition. What I'm humbly submitting that these Japanese show, unless there is an express prohibition, in the agreement, same thing, Hallsbury also volume given. Unless members, they are now saying, make out a new case, that Exhibit A is a tenancy agreement. Tenancy agreement, this argument they have made that case in the evidence. Now, tenancy agreement, Exhibit A, is not mentioned in the plaint and also not in the list of documents relied upon. So my first submission has been that they cannot go beyond the pleadings and there is no jurisdiction to entertain that case that Exhibit A is a tenancy agreement. For that, my lord, we have cited a judgment Supreme Court, kindly come to me on issue. Case made out beyond pleading cannot be entertained by court. 2018, 11 SCC 652 at paragraph 24-26. The other Supreme Court judgment also, we have not multiplied. Court cannot record any finding on issues which are not part of pleadings. Any finding recorded on an issue divorce the pleading is without jurisdiction. That's the language of the judgment I'm quoting. It is a settled principle of law that parties to the suit cannot travel beyond the pleading, so also the court cannot record any finding on the issues which are not part of the pleading. Now, this may kindly note, this I have cited only Exhibit A, for the Exhibit A cannot be looked into. Exhibit A cannot be considered for that, because that is not part of pleadings. So if you find that argument in our notes of argument, we have said, but Exhibit A cannot be looked into as a agreement of tenancy. A document look into, but do not look into as the tenancy. Next is without anticipating their argument, issue of 91-92. 1975 Supreme Court subsequent conduct is admissible to construe the contract.
Parole evidence rule.
Yeah.
Parole evidence rule.
By evidence. Then, my lord, 19th century Odisha says, unless if assuming exhibit A is the agreement of tenancy, if it contains all the terms of tenancy, then section 91-92 will be applicable. But if an agreement in writing do not contain all the terms and conditions of the contract, then 91-92 is not at all a bar. For that matter, we given these two judgments in a notes of argument will find we have mentioned 12 items, essential terms of tenancy, which are not mentioned in the exhibit A, which is alleged to be tenancy agreement. For example, my lord, on tenancy location, which floor? Ground floor or first floor or second floor? Because if a tenancy of a ground floor has got different right from a tenancy of a second floor. The first floor ground, a tenant has a right to the lawn and other things which are on the ground. Ground floor tenant has right to the ground area which is adjunct to my tenancy. The different that is not mentioned in the tenancy agreement. Secondly, it is not mentioned that what is the area of the tenancy. Their witness has given evidence on the area of the tenancies. So they themselves know 91-92 is no bar. The plaintiff himself having laid evidence in the terms of the tenancy cannot now raise the plea of section 91-92. And let's see our notes of argument. Lord will find, my lord, we have categorically mentioned that what are the essential terms of tenancy which are lacking in that agreement of tenancy alleged to be exhibit A. Exhibit A. We have given, for example, my lord, I have one example I have given to your lordship from the memory. Area of the tenant showroom not given. No, namely area of tenant showroom, and plaintiff himself has given evidence regarding area, oral evidence. So oral evidence admissible. Location and description of showroom has not been mentioned. Location, which floor, description, nothing is mentioned in this exhibit A, which is now alleged to be a tenancy agreement, which we are disputing. Exhibit A cannot be considered to be tenancy agreement at all. Without prejudice to that contention, if it is contended again, exhibit A is the tenancy agreement, then we say, even then, it does stand in the way of admitting oral evidence under section 91-92. There is not similar. Showroom is not mentioned on which floor. Then just goes to municipal taxes to be paid and borne by whom. That is not mentioned. Agreement is not silent regarding ingress and egress to and from the tenant showroom into the adjoining compound. The tenancy, so-called tenancy agreement, do not at all say that ingress and egress to and from the showroom is to the adjunct compound is prohibited. Vehicle and traffic. What are the amenities of tenancy of the showroom? No restriction has been mentioned in respect of user of the adjunct compound courtyard is a said agreement. No restriction mentioned. There is ambiguity in the agreement. That is why again why 91-92 is no bar. Namely, the evidence they have given, namely 4 ways. Tenancy, this exhibit A mentions the expression 4 ways. Nothing has been specifically mentioned regarding purpose for which 4 ways have been provided on the rear side of the showroom, leading to the compound and courtyard. 4 wide opening, 11 feet wide openings in the back of showroom, which makes the room for vehicle and human beings to proceed through that 4 openings into the just to step out and come into the compound. Therefore, right of access to the compound by on foot and also on vehicle was granted from the beginning, as conduct will show. For 50 years we have used that, more than 50 years. This is one term is not mentioned. Exists a 4 dimension. And not this sketch of showroom has been provided with oral evidence And we have quoted that what is the description? These 4 ways, what is the 4 ways? They are 12 feet wide openings in the back here. That is not mentioned. 4 openings without mentioning the width. Nothing is mentioned. Therefore, not section 9, anticipating if they argue the point in 91, 92, Evidence Act, that is no bar. That is why, Milord, we have cited these judgments, given a lordship, that parties. Then a company as alter ego partnership firm, just cite a Supreme Court judgment. Last, Milord, to kindly come to interlocutory judgments cannot be looked into. This is Division Bench Judgment, 1988, Calcutta, page 25, at paragraph 6. 1988, Calcutta, page 25, paragraph 6. The Division Bench Judgment. Following another Division Bench, which is 59. And the last is a Supreme Court judgment is there. Supreme Court in 2009, Volume 5, SCG 5694. A precedent is a judicial decision containing a principle which forms an authoritative element, termed as ratio decidendi, as in an interim order which does not finally and conclusively decide an issue, cannot be a precedent. Cannot be a precedent.
There is another Supreme Court judgment which says that the principle of res judicata applies in case of interlocutory matters also. That was a different issue.
Yes,
Payment of court fees. Once the court fees decided that the court fees are properly made, that cannot be agitated or raised at the time of final argument.
But, a judgment which is interlocutory in nature is not a final judgment, no doubt, and that has no bearing or relevancy when the suit has been heard finally.
But there is that judgment of Supreme Court.
Yes, or division bench of the High Court.
Supreme Court.
There is another one regarding Miller. I'm sorry, Miller. Give the reference.
I will give the reference next day.
On what proposition?
Once the application is decided, this was in respect of payment of court fees. Once it is decided, when an application is decided on the merit, that has an effect of res judicata.
In another application.
No, in the main suit. That was decided in case of main suit, and specifically in context of not in respect of injunction, payment of court fees.
Payment of court fees. That is not preliminary. That is interlocutory.
Even that point can be raised because suppose
not
anyway that
court fees is not a matter of the final.
Even injunction applications.
Not on the merits of the
yes,
case.
injunction applications are heard on the basis of annexures only, not on the basis of evidence.
Not evidence, and on whatever document annexed, and suit is heard on oral evidence given by both sides, and also in this case, many additional documents have been exhibited, which are not there at the interlocutory stage.
I will show the judgment on the next year.
That I should bless you, but I didn't know. But that only concludes the question of court fees, not the merits of the case. I am submitting, while the court is deciding the merits of the suit, deciding suit on merit, court should not look into interlocutory judgments given in that suit earlier.
That is not. Anyway, I will show you the judgment.
It is not a precedent. It is not a precedent binding upon the court. It's irrelevant. 1988 Calcutta and the 2 division judgment of our court, which is relying on very clearly says, without, as is well known, if I read 1988 Calcutta, have I got a copy here? No? The judgment of the division bench.
Sir, just a minute.
Muktagesh. Horipada Mujumdar.
Gujarati Education Society judgment.
একটা পেয়েছি সেই জন্য ওটা
তুমি এখানে দাও, স্ক্রল করো, আমি দেখে বলে দেবো।
কপি আছে ওদের জন্য
কম্পাইলেশনের ভিতরেই আছে।
Imagine, can it turns to page 77 of the compilation?
Page
and also get the judgment.
77 Muktakeshi daw.
Muktakeshi, yes, beloved. Please come to paragraph 6 at page 79. On the merits also we are satisfied that trial judge was justified in making the impounding order of injunction. The impugned order of injunction. Defendant has not yet filed his show cause against the plaintiff's application for injunction, and therefore at this stage, all the statements made in the application will have to be accepted as true to be made at et forma. And when so taken, a allegation in our view makes out a case for ad interim injunction. As and when such so called
স্ক্রল করি স্যার জাস্ট এ মিনিট জাস্ট স্ক্রল করো আরো করো আরো নিচে নামো
Oh, rejection.
আস্তে 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 নামো উপরে ওঠো ব্যাস ঠিক আছে আমাকে এদিকে দাও আমি স্ক্রল করছি ওটাকে পুরোটা বার করছো দিয়ে দাও ঠিক আছে ওকে আই উইল গিভ ইউ
Got it? Reference, if you
আই উইল গিভ ইউ
This paragraph 6, I'm middle of that paragraph. As is well known, middle, as is well known, finding arrives at in dealing with the application for temporary injunction pending disposal of the suit, even if they relate to any matter, any material question involved in the suit, cannot take the place of finding in the final decision of the suit, if any, citation is necessary for such well-known, well-established principle. Reference may be made division by decision of this court in 1959 Calcutta CWN 690-694. A fortiori, therefore, the findings, if any, made by us in disposing of the appeal against the impugned order of ex parte injunction cannot in any way take the place of finding to be arrived at in disposing of the application for temporary injunction now pending before the learned trial judge. But on material shown on record, we are of opinion learned trial judge was not wrong in making the impugned order. This is not relying 59 CWN. That judgment I have not given, also I can give it also to the judgment. And if it also now comes Supreme Court judgment at running page 88. Please come to page 88, running page, paragraph 21. Two paragraph. A precedent is a judicial decision containing a principle which forms an authoritative element termed as ratio decide and die. An interim order which does not finally and conclusively decide an issue cannot be a
now here a distinction is made. One important thing is that an interim order which does not finally decide. So two interim
finally
orders,
decide.
one
Decide the
finally deciding, another is not.
finally decide the suit. Made it the
Finally and conclusively deciding an issue. So injunction application, these are tentative findings.
Tentative, all tentative finding. That's to be saying. Therefore, any interim in direction issued on the
Sir,
basis
just a
of
minute.
such prima facie finding are temporary arrangements. That's item B. Punta. Just reading at page 88.
No, please see this judgment reference. We may take the.
Oh, this is. My lord.
It is another judgment.
Get put to mail. This is maybe.
I have quoted certain in referring to another judgment.
Well settled principle res judicata can be invoked not only in separate subsequent proceedings, they also get attracted in subsequent stage of the same proceedings. Yes. Once an order made in the course of a proceeding become final, it would be binding at the subsequent stage of the proceeding.
So one thing is final order, another thing is not final order.
These are all procedural orders.
Yes.
The procedural orders.
Not touching the merit.
The authority for this beginning is 1966 Supreme Court.
1966
Supreme Court. Let us find that. A procedural order, suppose court decides today that I shall be in the application, that this issue number 1 will be taken up first. Then we shall consider other issue after consider. That is the procedure that is final.
That cannot be changed.
That cannot be changed. This is eliminated.
Not substance.
Not the any matter on merits, because the interlocutory order, all either procedural orders giving direction, discovery of document, inspection, etc., something, or giving an on prima facie satisfaction, passing an order, say that, let us say, the plaintiff has the right to ABCD.
These cannot be finally decided.
And that right will decide upon taking oral evidence.
Oral, documentary, whatever that might.
Whatever further documents. Therefore, what can you see? This judgment, please see, what is the procedural matter? I'm reading the issue of pecuniary jurisdiction, along with sufficiency or insufficiency of court fees, was agitated before this court. Pecuniary court fees adequacy. Issue was decided by the coordinate bench of this court, Supreme Court, in terms of order dated 19 July 2005. A coordinate bench of this court observed.
No, this is my part. I'm not reading out this one. YB Patil, I'm referring to YB.
In the light of that, what was the nature of the order involved in this case, in the Supreme Court? Matter of sufficiency of court fees.
Yes.
Once the court decided, yes, court is sufficient, subsequent stage, it cannot be reopened, unless you have preferred appeal from that. Of course, in our case, no orders were, appeal was prepared and set aside. Now,
these are in respect of different issue.
Yes. Regarding paid court fees observed, order deciding the nature of the court fees to be paid would be a judgment, but this affects only plaintiff or the government and not the defendant. Next judgment, 1981 4 SCC quoted, but this will affect only plaintiff or the government, not the defendant, court fees. Thus, only the plaintiff or the government, as the case may be, will have the right to file an appeal in the division bench and not the defendant, because question of payment of court fees is a matter between government and plaintiff, and defendant has no locus in this regard. Whether it's correct or not, I'm making any comment. Because proper court fees are not paid, suit cannot be heard. There's a defendant right to say, no, plaintiff suit cannot proceed unless proper court fees are paid. And anyway, Supreme Court said this. Therefore, the ratio is a matter in an order which a procedural order, which does not affect the merits of the claim. It does not affect the prayer A or prayer B of the plaint. That is not admissible evidence. That's what the 2009-5 SCC have laid down again. Apart from our division, two division judgment in 88 Calcutta and 59 CW. 59 CW has given the reasons, and that has been followed in 88 Calcutta. We have not given 59 in the compilation, but you can.
It can be looked into.
Good. Then Supreme Court says, what Supreme Court says, beloved, is this. It is an interim direction, is of status quo, direction of such prima facie finding are temporary arrangements to preserve the status quo till the matter is finally decided. Why, upon the suit being disposed of, why all interim orders stand vacated automatically? If they receive the finality, then that should remain. After decree is passed, if injunction has been given temporarily by court, that should continue. That would not, because the interim matters are not on merits, and they cannot separate as court to language Supreme Court to make a prima facie as a temporary arrangement to preserve the status till the matter is finally decided. When the matter is finally decided, what you interpret is of no relevance. The observation and direction of Kapil extra judgment being interim direction based on tentative reasons restricted to a peculiar fact of that case involving an extraordinary case in human rights, that is very good. And the paragraph 21-22. And so our Supreme Court, our judgment said, may stand to reason also, my lord. Stand to reason. That's item C. It is not possible to reach such tentative reasons as final conclusions as contended by the respondent. If those observations are taken to be final decision, it may lead to every disadvantage upon group of every citizen and every them employer facing, etc. High Court approved extreme hardship, etc. But with respect to Supreme Court, my lord, Supreme Court should have said that there cannot be two final decisions in a suit.
Right.
The decree is a final decision, injunction by interlocutory also final decision.
Injunction cannot be because
Cannot remain.
the right of the parties' right duties cannot be decided in vacuum. It may be temporarily or tentatively decided on the basis of some documents.
Some documents.
But for further decision or actual decision, oral, documentary, both kinds of evidence may be needed.
Documentary and oral, both.
And if it is decided at this stage, then what will remain for the suit?
That's right. That's right.
That cannot be
and
finally
also,
decided.
that's a settled principle of law. At the interlocutory stage, the interlocutory court cannot decide that final reliefs.
Yes.
That's also settled principle.
Yes.
So, my lord, with my judgment, my lord, my letter has noted, my dear points out
that is in a read
that
proceeding.
key which is
This is the summary proceeding.
that is a read proceedings.
So not in a suit.
There were two kinds of proceedings, which are decided on affidavits only, and other decided
The concept is very clear.
on
Whether writ or whatever that might be, on the basis of affidavit, you cannot prove anything.
cannot find it.
When the suit, there is a scope for adjudicating the matter, taking into the evidence.
Yes.
Affidavits cannot be substitute of evidence.
Or correct. Into affidavits are not even documents.
Not even evidence.
Not even that's right. Not even evidence. That's correct. So many that cannot be seen what they've said and all that thing. This
Only tentative findings for the time being.
Time being till the suit is finally decided.
So that the suit or application is not frustrated.
That's right. Supreme Court is a expectation to preserve the status quo. To preserve the status quo, it should be done. That is not judgment. And the notes of argument without heading, can you take the just heading? I shall give you a lot of index, prepare the index of the notes of argument.
Yes.
See what are the first stated facts in brief. Code issue. Code issue of sin, which is already. Then our issue framed in the suit. We have quoted. See the index, my lord?
Sir, let me hear on the next day your other side. Then I will hear the reply.
Yes, certainly. Oh, great.
For the timing, your argument, let it be concluded for your argument. The reply will be heard later on.
Depending, we don't know what they will actually argue. Let them argue.
You will give reply.
That is.
Heard in part. Sir, which date?
I was thinking that in the middle of next week I will not be here. My lord, it should sit on Lord on the 6th or 7th one day, and then Lord the 13th or 14th. 14th.
Hatara daw na.
Tana ni na. 6, 7, 12, 13, 14 ni na. What should be done?
One day now, and then Lord, I shall give the other dates on the next day.
Prepare any date after 14 February.
I can do it on 7th also. 7th of February.
When sir, not possible. 7th is congested.
Then any day after 14th. 2 consecutive days I will. How many?
18 is okay?
Yes.
18th February.
Grateful.
Well, my presence is no longer absolutely essential.
Sir, we always need you. Your presence is always needed.
Then I shall come. It has been a pleasure to us.
This High Court cannot be without you like persons.
I've just cited the judgments because I've seen, my lord, how quickly Lordship reads the judgment and said, this is understood. Now come to the next judgment. So that's why I've given the index of the judgment.
Sir, what
with
you
the
say?
keywords.
Defendant cannot raise dispute regarding payment of court fees
That is not correct.
Because
I
suppose
should say.
I sued you, paying insufficient court fees. You have every right to object to that.
Certainly.
You can always say the suit is not maintainable.
The Supreme Court says
We have
how
to
can a
abide by it.
defendant can certainly the suit is undervalued under court fee. See the civil procedure
And
code.
in fact, that is a ground for rejection of plaint.
That's right. Can you see there's orders were rule 11 now? After amendment, a specific ground, the suit is undervalued.
Yes, valuation, of course, that was decided in the year 1974. Subsequently, CPC was amended. 76.
Amendment, yes.
So that judgment is no longer applicable in
Not
this respect.
Deficient court fee if not put in, the suit can.
Subsequent amendment.
Suit is undervalued also.
Whatever, related to valuation.
And not defense has a right to say that the suit should be dismissed.
Possibly that is this judgment is the reason why this amendment was made.
Law Commission
Must have been taken into consideration.
Yes, no, because we cannot say Supreme Court is wrong, but they can amend the law.
Supreme Court was right in respect of that existing law. Maybe.
relevant part of
Not
Obligement.
from the countries